Click agreements are everywhere in the digital world now. As a contract for software licenses and online transactions, they are included with nearly every piece of software that can be downloaded and installed. The user must agree to the terms and conditions prior to using the product, usually by clicking an OK, Accept, or Agree button. If the user rejects the agreement by clicking a Cancel, Disagree, or Decline button, the user is unable to use the product. These agreements detail the implied warranties and limited liabilities, among other legal matters, that the website or software will be afforded while the user is using the service. The legal case of Specht versus Netscape Communications Corporation is an interesting case in the world of click agreements. The facts of the case are as follows. The plaintiffs, Specht and others, downloaded the defendant Netscape's software. During the process, they clicked Yes, assenting to the terms of the click agreement. However, when downloading the software, there was no presentation of the agreement, and the license terms were only visible if the plaintiffs scrolled beyond the download button. The plaintiffs had an issue with how the software worked and brought it to court, where the defendant tried to stay the court action and initiate arbitration, because an arbitration clause was written in the contractual terms that the plaintiffs agreed to. The motion to compel arbitration was denied the defendant because the court held that the plaintiffs could not have reasonably learned of the existence of the terms before downloading. Therefore, the lesson from Specht versus Netscape is that, according to the courts, click agreements are enforceable as long as the terms are conspicuously presented, and it is clear that checking the box is akin to agreeing to the presented terms. This seems to be a fair rule. However, it should be acknowledged that the reason click agreement enforcement has become so controversial is that the terms simply being presented conspicuously doesn't help when the terms are extremely difficult to read by the consumer, or they are so long that they actively keep users from reading through them. In their current state, where they are indeed very long and relatively difficult to understand, the average consumer cannot be expected to read through it all. So the ruling of Specht versus Netscape is helpful to the user, but not helpful enough to fully answer the issue of click agreements.